So first up, we'll hear from Professor William van Caenegem from Bond University, and he will be taking us through geographical indicators around food.
Thank you very much. And thank you, Matt, for inviting me to speak today. I don't know how many of you have actually heard of geographical indications of origin as a topic, but in some parts of the world it really keeps people excited and interested. Basically, geographical indications of origin are place names that are used to not only indicate the geographical origin of goods, but also certain qualities that are derived from that particular origin. So they're typical products of a region. For instance, champagne is obviously the best known example probably around the world, and the most active litigators around the world. More controversially, feta is another example. Parma, like in Parma ham. Burgundy, Stilton, so it's not just France and Italy we're talking about. Or Scotch whisky, that's also a geographical indication of origin. So there's very much a traditional European kind of regulatory framework you have around geographical indications of origin. It's really a sui generis area of law that in Australia we have not known, and in the common law world we've hardly known at all until quite recently. In Australia and in the US, and we follow the kind of US example quite substantially in this area. Traditionally, the role that GIs play in Europe is played by certification trademarks. And partly that kind of pushing of certification trademarks in those countries is motivated by trying to keep GIs free to use in a generic sense in countries like Australia and the United States. For instance, the term feta for us is a descriptive term, describes a style of cheese rather than a cheese necessarily coming from a particular area in Greece. Now GIs, so I said in the US and Australia, we tend to push certification trademarks and regular trademarks as the alternative to GIs. But in reality, GIs are a very different beast from certification trademarks. Firstly, a registered GI concerns an actual place name. It concerns, in other words, a descriptive term. As you know, one of the basic requirements of trademark registration is distinctiveness, not descriptiveness. So normally it's quite difficult to get a place name registered as a trademark. You have to show a lot of acquired distinctiveness so that the mark has been, or the term has been used for a long time as a trademark. But normally, in principle, it should be very difficult. The same applies in reality to certification marks as to standard trademarks. So a GI registration model overcomes that problem because you're actually registering a descriptive name as a descriptive name. That's the essence of it. GIs are also not private property. A trademark is private property. It's an individual or a company that applies for a trademark and then owns that trademark. That applies also to certification trademarks as to other trademarks. GIs are a little bit mysterious in terms of property, but they're certainly not private property. They're either collective property of a community of producers, or they're state property, or they're simply not property at all. The essence really of what you do with the GI is to very precisely delineate an area as being entitled to use a particular name, and then you also have specifications that apply to the product to which the GI attaches. For instance, for champagne, it's very clearly delineated by law, gazetted if you like, where champagne begins and ends. Secondly, there are very strict rules as to how champagne is to be produced. You've all heard about those in terms of the varieties used, in terms of the techniques used, in terms of how long the wine has to be stored before it can be released. All those sorts of things are prescribed in great detail. What that means for the consumer is that they have a relatively clear message when they see a GI as to where the product comes from, within that particular region and the kind of qualities they can expect from it. Naturally, within those GI spheres, individual companies, etc., can still compete on the basis of their own brands as well. That's why you know all the different champagne brands. It's not some one champagne block of producers. But all those producers have to follow those particular rules if they want to use the term champagne. Of course, if they don't want to follow those rules, they can still make a product in champagne in whatever way they like, with different grape varieties or whatever it might be, but then they can't call it champagne. So it's a kind of monopoly over the use of a place name. Now, the GI protection regime is a very absolute one. It's very different from trademarks in that sense. There's absolutely no requirement to show any kind of proof of consumer deception. So if somebody puts the term champagne on a wine produced in the Barossa Valley or whatever it is, when you sue them as the wine growers of Champagne for infringement of a GI, you don't have to prove that consumers are misled into thinking that wine actually came from Champagne or anything like that at all. It's completely prohibited to use the term. So you're not allowed to put Champagne style or kind. You can't indicate very clearly that it's Champagne that actually comes from the Hunter Valley or anything like that. None of that helps you get away with it. So it's a very, very rigid and absolute regime. By contrast, in trademarks law, you have a lot of derogations and exceptions. For instance, use in good faith of a place name is an exception of trademark law. So if a place name happens to be registered as a trademark, if you're actually doing business in that place and you want to indicate where you're based, you can use that place name. Under the GI regime, that's not permitted at all. Basically, what we're talking about with GIs is a kind of very product-specific regional branding mechanism. Now, there's been a lot of opposition to GIs in Australia because the Europeans traditionally have tried to, through TRIPS and post-TRIPS, have tried to expand protection for their GIs around the world. The luck that the Europeans have in this exercise is that a lot of these GIs are quite well known in other jurisdictions. We know a lot of European GIs in wine styles, in cheese styles, in processed meats, etc. We use them day to day here as generic and descriptive terms for things that are actually made in Australia. What the Europeans would like is that we stop using those terms and that those terms are reserved to their producers in their particular regions following particular rules that we stop doing that. Take feta as an example. Feta is a registered GI in Europe, which already is a little bit strange because it's not actually a place name, but it's a registered GI. So in Europe, feta can only come from an area in Greece and be made in a very particular manner. So you can't have Danish feta anymore, you can't have Bulgarian feta, things that you used to have before feta was registered as a GI. As you know, in Australia, there's like tens, if not hundreds of kinds of feta that you can buy. There's low-fat feta, there's cow's milk feta, goat's milk feta, sheep milk feta, there's creamy-style feta, there's Bulgarian-style feta, there's Danish-style feta. There's endless varieties of that. That's completely impossible in Europe, but it also kind of awakens the ambitions of the Europeans who say, well, sorry, you should stop doing that because feta actually means a Greek particular style cheese, and for those other things that you make locally, you need to call them something else. And then the problem is, of course, well, what are we going to call them and how are we going to educate consumers that it's the same thing? So there's been this kind of long argument between the Europeans and a lot of the English-speaking world, if I can use that term, a lot of immigration-based kind of countries like in America, also South America and Australia, because we tend to resist that push for the Europeans to extend their rights over GIs. Because that's the case, there had been very little research done in Australia about what the merits of a GI system actually would be. We have a GI system for wine, which we entered into because of a treaty with the Europeans, but we don't have a GI system for other foodstuffs. So some colleagues and I decided we would ignore for a bit the kind of international strategic negotiation arguments which compelled Australia to resist the push for GI protection and clawing back GIs from Europe, and to see whether there was actually a good policy argument for having a GI registration system for food in Australia. So those two reports there, sponsored by the Rural Industries Research and Development Corporation, were the result of that. And we conducted over 200 interviews in various parts of Australia to try and kind of find an answer to that question. And we recommended in the end of our main report that we should consider introducing a GI registration model for food other than wine. It's a bit of an odd situation that Australia is in, trying to argue against GIs and the expansion for GI rights pushed by the Europeans, because we actually accepted having a GI system for wine under pressure from the Europeans. And a lot of people argue that since we did that in the mid-90s, in fact, the wine industry has grown exponentially. We've exported enormously to Europe in particular, and the European wine industry has kind of developed its own character around its own GIs, Coonawarra, Barossa, Hunter Valley, but then also around its own brands like Penfolds, etc. So partly the question was, well, if that seems to have worked somewhat in relation to wine, could it work for food as well? So there were a few conclusions we came to. One was in relation to the fact that having GI protection is very effective protection against free riding. What happens if you don't have a GI? A good example is that we came across was something called Bangalow pork. Maybe you've heard about it. Bangalow is a little place near Byron Bay, and a few producers there, on a voluntary kind of basis, decided to adopt a certain feed regime for pork, for pigs in other words, that produces fatter and more tasty pork. And that was an expensive feed regime, so they needed to be able to sell that at a premium. And that worked quite well. So restaurants paid a premium for this type of pork, and some butchers, etc. as well. The problem was that after a while, when they'd established that reputation, people started to free ride on it. People who were not actually in Bangalow, but more maybe in Byron Bay or one of the Lismore or somewhere like that, not Bangalow, but near enough to maybe be able to argue it's a bit the same. And also people using a much cheaper feed regime, so going back to the standard feed regime, and then just sticking the name Bangalow on that and getting the premiums. So that's for producers, but also restaurants would simply buy ordinary steak and put, pork, whatever that is, and put the name Bangalow on it, and then that would cost twice as much on the menu. So that's a free riding problem. With a GI system, you kind of overcome that. If Bangalow pork was a GI, then you would delineate exactly where's Bangalow. It could be the council area, but it might be that traditionally some other parts have also been known as Bangalow, so you might include that. And secondly, you can impose the rules that apply to that. You say, well, this is the feed regime that you have to follow. You can't have cheaper stuff or something like that. So then the moment somebody puts Bangalow pork on some pork that doesn't come from Bangalow or that hasn't followed those rules, that's an infringement of the law. You don't have to prove consumer deception or anything like that at all. So it's kind of a simple model, and it seemed to us that could have some merits in some places. So it would enhance the incentive to invest in high quality rural food products and production. Second thing that we came across was that there was often in rural areas, people would try to brand their area, say for instance the Atherton Tablelands or something like that, and they would collaborate on trying to promote that area as a source of a lot of good food, but usually it was different kinds of food. It might go from meat to specialty fruits to high quality veggies, etc. They all tried to promote that under one local banner or local place name. Time and time again, we came across the same story, and that was that over time that always fails. People start to fight over the different interests of the different products. You have a champion in the beginning, but that person gets tired of it all and gives up. They fight about the standards that you should apply. It all costs, and people have to contribute, and they refuse to do that. And we found over and over again these types of effort tended to fail. With the GI, because it's a legal regime, if you like, really the operators, the collective owners of the GI, which is in place forever. The name isn't going to change. The borders aren't going to change. That's a much better focal point for collaboration about quality production. A really good example was a new wine GI, the Granite Belt. You've probably heard of that. It's the only real Queensland wine GI. We did interviews there, and those people said, yes, this GI has really driven us all together as wine growers here. Most of them were of Italian extraction and all kind of knew each other quite well. But we've worked very efficiently around this GI, around the wine. We've been able to promote it quite effectively, et cetera, which takes me to the next point that we found, and that is that these GIs tend to have a spillover effect. So the GI in the Granite Belt had a really positive effect for other producers, for instance, of apple juices, etc. Stanthorpe used to be an apple growing area. That's completely disappeared. A lot of old apple growers still kind of live there, quite frustrated about that. But because the Granite Belt is a well-known wine GI, people go there for weekends from Brisbane above all, and then they use local accommodation, and they also try other local products. For instance, value-added products based on apples like ciders and apple juices, etc. So that seemed to be a positive effect as well. Next point is that it seemed to prevent privatization of place. You've probably all heard of King Island, yeah? King Island beef and King Island dairy. It's a typical kind of example of a problem you can have where place names can become registered as ordinary trademarks. So the King Island beef trademark is owned by JBS, which is JB Swift, which is the biggest kind of meat processor in the world, a Brazilian company. And the King Island Dairy brand is owned by Lion, which is actually owned then by Kirin, which is a Japanese company. So you have enormous corporate interests who own private trademarks in the place name. So the locals can't really control what they do with that. So there's always a constant concern that those companies will really move production off King Island onto the mainland of Tasmania, or they will bring milk from Tasmania onto King Island to process it there into cheese. And those are things that you really can't do much about as the local beef producers or dairy farmers, etc. So there is that sense that in Australia it's quite easy to obtain a trademark in a place name, but that really hands control of that place to some degree, even to a large extent, to corporate often interests. Which might be at odds with local interest in maintaining local production, local employment, and making the place attractive for tourists, etc. as well. Obviously, there are downsides as well with GIs. One of them is you have another regulatory structure, and you'll have costs and policing, etc. And also with the GI, Europeans have the advantage because they're GIs. Many of them are quite well known already, so you don't really have to invest so much in promoting that GI. Everybody around the world in industrialized countries knows champagne, so that's a big saving in terms of the promotional cost. If you start a new GI in Australia, you're going to have to promote it to your local consumers and perhaps overseas. That's an expensive exercise. So those were a few of the conclusions that led us to say, well, maybe we should introduce GI system for food, but a very low cost and flexible model. The other argument stems from the fact that we already have a wine GI system. So where's the logic in having a system for wine and not for other food? It doesn't seem to make sense. Although traditionally, GIs are very much associated with wine. Because of the whole question of terroir and because wines are very typically kind of linked to a particular environment, supposedly. Now, we have an Australian wine GI model, but it's a very, very strange one. We entered into it, in a sense, to meet the European demands to protect their wine GIs in Australia. So we created a register for that purpose, but then we also allowed Australian wine regions to register as well. So Granite Belt is one, Hunter Valley, Coonawarra, Barossa, they're all registered GIs on our register here in Australia. But oddly enough, the only requirement that attaches for a wine GI is that 85% of the grapes have to come from that area. So you could have a wine and put Barossa on the label, but in fact the wine could be made in Brisbane, as long as 85% of those grapes actually come from the Barossa. Also, second point is, there are no specifications in Australian wine GIs. In other words, it's really only a rule of origin. And that's why if you look at these famous wine areas, you find white wines, red wines, sparkling wines, Chardonnays, Sauvignons, everything you can think of. If you go to Champagne, that's not the case. You have one variety or a couple of varieties that are allowed, and then the specific methodology, etc. So our wine GI system is very different. It's much more flexible, which takes me to one criticism of GIs that you find, and that is that they are very conservative, that they set in place ways of doing things which then are very difficult to alter. Think about champagne, for instance. You have the process, of turning the bottles. Traditionally, that has to be done by hand. And then the question is, well, can we move with the times and have machines do that? And it becomes a huge issue in terms of the GI regulations and specification, when that can be done. In Australian agriculture, we have very much an innovation focus. We don't really want to be bound by these kind of rules. And therefore, there's been some pushback on that basis against GIs as well. But the wine GI model actually is a nice compromise because you have a GI protection, but there's no specification, so you can do whatever you like as long as you use 85% grapes. Any kind of style, you can have innovations in technology, you can adapt to global warming and all those problems that they have in the wine industry now. There seems to be a kind of coincidence between Australia dropping the right to use European GIs and developing its own GIs and the success in the export sense of that wine industry. Exports from the mid-90s, when we had this change about GIs, have skyrocketed. It's a bit much to say, well, that's because of your GI changes. That's probably exaggerated. But it's certainly important that there was a kind of switch from being a more imitative industry and always coming second best. You're always producing something European, but it's not actually quite European. I mean, it's a good market for that, but it's a limited market, to having your own character for your wines, which is partly also driven by your kind of focus on innovation and new wine styles and stuff like that. It's a kind of an interesting example, the wine GI system, but because of its odd character where it's no specifications, that's not really the model for food. For food, you're going to have some specification. Let's say, for instance, King Island beef is a registered GI. Well, you're going to have to decide how long cattle have to spend on the island before you can call them King Island beef, which is a big kind of issue. Is that 6 months grazing, or is it 12 months? And you're going to have to decide, well, do they have to be grass-fed? Yeah, at least for X amount of time, they have to be grass-fed. Otherwise, it's not going to reflect the character of King Island at all. So it's very hard to envisage a food GI system without any kind of specifications. An example we came across was also Mariba mangoes. Mariba is on the Atherton tablelands. For some reason, Mariba mangoes are quite well known in certain parts of China as quality mangoes. People prepare to pay more for them. Well, if that was a GI, you'd have to say, well, where's Mariba? And when we did interviews there, people are not at all sure where Mariba begins and ends. And then you'd also have to specify, well, at least a certain variety. And very important for mango growers was also not picked too early or too late, because that's a real problem in the industry. People pick very early because you can get very good prices in the market, but the quality is very low because they actually unwrap. So you try to overcome that with some specifications. Sorry? 3 minutes. Oops. Yeah, you're right. There's other kind of points in relation to GIs versus other ways of fighting consumer deception about place of origin and quality of product. You can rely on a trademark or on passing off and Section 18. Being in the law, we all know, well, that's incredibly expensive. And that's really hard to do. The GI system is a much simpler one, much cheaper one in that sense, because it's also one where people collaborate and can share costs. A constant refrain we found in the country was, oh, yeah, our brand is being ripped off, our place name is being misused, but we can't do anything about it. It's too expensive, and I can't trust lawyers. Full stop. Yeah, we just said, well, yes, you can trust lawyers. It's a great argument to run. Yeah, So a GI system will also create perhaps more clarity about origin, where in fact in the Australian market, in terms of trademarks and in terms of common law marks, there's a lot of playing fast and loose with regional origin. I think I'll just add one more kind of thing which relates to, we did a second report which related to overseas protection of regional or place name brands. So, and an argument we made was that if you introduced a GI system here, then you would also be able to protect those GIs as GIs in, for instance, China and Japan. And we did interviews there. China and Japan have a sui generis system based on the European model, and most Asian countries have that now. So Asian countries have really bought into the GI system. And because we don't have food GIs ourselves, and because we take this stance against them, we can't play along with that game. And we kind of made the argument, well, you should really consider whether it is worth getting into the GI game, and then you have something to haggle with, then you have something to protect overseas. The biggest fighters for GIs in China are the Scotch Whisky Association. Tasmanian whiskey was a GI kind of possibility that we had a lot of discussions about with people over there. So we really should consider introducing GIs for the purpose of international trade. And then this will be my final word, in terms of broader agricultural policy, to move from commodified agriculture to high quality, locally produced products, for which you get a much higher return, and you kind of escape the competition pincer of economies of scale. So I'll leave it at that thing. Thanks.